I'm Sarah and I'm hosting today's meetup. So, our topic for today is the legal risk of being a non-executive director. Hopefully, something you've thought about before. And Joe's going to touch on the impact for trustees as well, in case that's your role. So, Joe Haigh. Joe is a chairman and a founder of the FDS Director Services, and that's since 1989. And she's worked on over 400 transactions. It's a heck of a lot, Joe. In 2018, Joe also founded OnBoarding Officers, and that's how I heard about her, an exclusive community for exiting military officers to help them transfer their skills into the commercial world and become world-class business leaders. Joe is a published author of 7 books, one of which was published for the Financial Times. Throughout Joe's career, she has sat as a NED on numerous boards around the country and is currently a NED for 5 companies, one of which is a publicly listed company. Over the years, Joe has been awarded and acknowledged for her outstanding business achievements. These include Sunday Times NED of the Year and NED of the Year for the IoD Yorkshire Northeast. So, Joe, over to you. Thank you so much for speaking for us.
Hi, everybody. Thank you so much for inviting me today, Sarah, and thank you for the lovely introduction. I teach hundreds and hundreds of people every year on how to be boardroom ready. And of those, I would say a good 90% have got absolutely no idea at all what it means to be a director, whether an exec or a non-exec director, in terms of their liability, and very little understanding of the risks. So everything I'm going to tell you about, and Sarah actually prompted me to add this to our talk this morning, applies to both executive directors, non-executive directors, and trustees. Now, you might think that trustees have limited liability, but unfortunately, many trustees act like directors unknowingly. So a trustee should act more like a shareholder, in other words, reviewing and ratifying decisions. If they start getting involved in decisions, they become directors, either shadow directors, and a shadow director is defined in the Companies Act as someone whom the other directors are used to taking advice from, or a de facto director is somebody who just starts to act like a director, what one judge called brain on strategic decisions. So of all the thousands of people I've taught over the last 30 odd years, these people, whether execs or non-execs, believe that I work for a limited liability company. There is something called an unlimited liability company, guys, but they're very rare. You're unlikely to get a job in those. But most businesses in the UK have got limited liabilities. But I want to make it clear that it's the company that has got limited liabilities. Directors have unlimited liabilities. You can lose everything. Now, I don't have any get out of jail cards, but I have lots and lots of fire guards. One of the most important fire guards is to get yourself a really, really good service contract. And if you are working through your own personal service contract, it will be a contract for services. And often appointments are just done either on a handshake or a letter of appointment. They're just not good enough because it doesn't contain some of the really important protections that you need. So while you can lose all your assets and you can go to prison and you can get disqualified, which, believe me, is not a career enhancing prospect. And I was just checking again some stats for this presentation. 210,000 directors are investigated every year. Now, of course, not all of those get disqualified, but a fair few do. So this isn't a job to take lightly. Winston Churchill said, with greatness comes responsibility. I'm afraid Joe Haigh says, with greatness comes liability. Now, if you can imagine, if I'm running a course for a day or 2 days, there's often people going, oh my goodness me, why would I do this? It's so full of risk. And it is. And over my career, I've had a few near misses, and I've been very glad of having certain things in place, not least of which directors and officers liability insurance. Though I should perhaps tell you that that is not giving you the right to commit an offence. It would be like having insurance on your house for fire and then setting fire to it and then asking the insurance to pay out. It does not pay if you commit an offence. It pays legal costs to support any issue that might arise in your tenure. Really important, ladies and gentlemen, is your liabilities last forever for anything that happens on your watch. for criminal offences, which includes health and safety. For civil offences, it lasts for the statute of limitations. When you are looking at directors and officers liability insurance, which I would not take up a role without it, it's paid for by the company. It's not expensive insurance at all. It's about £1,000 per £1 million worth of cover, and it's paid for by the company. The word officers will cover you if you're not a statutory director. You must have run-off cover in that policy, because if the policy doesn't have run-off cover, you are not covered when you leave that business. It only covers people in post. So it's really important that you have that. And I mentioned the service contract. That is one of the things that you need a contractual right to, because it's not a mandated cover. Believe me, you don't want to be disqualified. As I've mentioned, the number of investigations are increasing year on year, particularly since the 2006 Act for Directors, which have got, for the first time ever in law, a list of things that you have to do or mustn't do. We've always had things that you should do, but it's always been in common law, so much more challenging to interpret. The other thing I should tell you is that being a director is not just how good you are. We have a concept called joint and several liability. Now, I don't know if I'm talking to people here who are actually got some sort of legal background, but for those of you who haven't, joint and several liability means you are liable on behalf of others. So if we're all on a board and one of us does something that creates a litigious action, it won't necessarily be that person that will be litigated against. You could be litigated even though you've not done anything because of this joint and several liability. That is why directors and officers liability insurance is so important. Just to give you a few up-to-date stories about what's been happening. I'm sure you've all heard of the Carillion debacle, where multiple directors are being prosecuted. It takes years. It can take up to 8 years to bring a prosecution against a director. By the way, if they are disqualified, the average is 8 years. But however long you disqualify it for, that disqualification sits on Company House forever. So even if you're disqualified just for 2 years, which is the minimum, anybody doing any due diligence on you, they will see you've been disqualified, which is clearly not a career-enhancing thing to happen. And those directors are being prosecuted because of their aggressive accounting practices and the massive debt that they ran up. So effectively, they were trading insolvently. They had suppliers that they hadn't paid for over a year. The other one is Thomas Cook's, you know, the oldest established travel agent in the UK. And they failed because they were using deposits for people who were paying for a holiday this year to pay off last year's hotels. So clearly, again, trading insolvently. Now, trading insolvently is not the most litigated offence against directors, believe it or not. Actually, not filing accounts properly is the most litigated, followed by health and safety. But then it is trading insolvently. And that is something you need to be very aware of, because under the insolvency legislation, you are deemed to know whether you are trading properly or not. So there is two kinds of insolvency. There's fraudulent trading, where you definitely know, which is what Carillion and Thomas Cook directors are being sued for. That carries a 7-year prison sentence and up to 15 years disqualification, which is the maximum period. And then there's wrongful trading, which is a civil offence where there is no reasonable prospect of a solvent winding up, and you do not change your allegiance from looking after the company, which is what directors must do, but to looking after creditors. All this, and of course, all the laws I talk about, you're deemed to know. So you do need to understand what it is that you're letting yourself in for. When I join a board, I often find that the directors around the table have got no idea about any of this. So massively important. Now, this doesn't apply just to paid roles. Obviously, Carillion and Thomas Cook's, etc., they were all paid roles. But the kids' company, the directors of that company, were not paid, and they were disqualified because of the poor financial management and questionable governance. And I would say that one of the top roles you must see is to make sure good governance practices are in place. Governance is, by the word, not very exciting, but it is essential that you run proper board meetings, that you keep proper board minutes, and you don't allow the people around that table for the meeting to disintegrate into a management meeting. I think the funniest thing I ever had was at a client where they spent 20 minutes talking about the fact that the milkman had retired and what were they going to do for coffee, until eventually I said, well, I know, let's just get a cow, because then we don't have to worry about it. And they said, Jo, are you taking the you know what? I said, no, but 7 of us spent 20 minutes talking about the milkman. Do you really think that is good use of our time? So the non-exec, you have to get people focused on what we're there for. And it isn't a management meeting. I've got a few more examples, but this patisserie Valerie, of course, where the finance director took over £40 million out of what is largely a cash business. I'm not sure what those balance sheets and profit and loss accounts look like, but one thing I would say to all the people I work with, if you cannot read a balance sheet, you should not be on the board. You have to be able to understand the mechanisms of the financial management of your company, not to the extent that you are the finance director, absolutely not. But if you can't understand the basics of balance sheets, so you don't understand about gearing and return on capital employed and return on equity, then you need to sharpen up on that, because you'll find the people around the table with you have got very limited understanding, particularly in SMEs. Now, other than my public company role, I've spent my entire career working with SMEs, and those aren't necessarily small businesses. You know, some of the business I work with are 60, 70 million, so they're not tiny, but they make up 99.3% of all businesses in the UK. And that is where all the excitement is. I love working with these people. They can make lots of decisions very quickly, but they're often very naive on governance. And record keeping is hugely important. And I've been in the position where I've had to have those records available to manage the risk. What are some of the things that you should be looking at? Please, please urge your boards to take health and safety and risk very seriously. There's a download you might like to get. It's from the Health and Safety Executive. It's called a Health and Safety Guide for Directors. It says what you as directors, not as management, should be aware of in looking after the health and safety in your business. And one of the things it says is health and safety should be really high up on your board agenda, so that you can show how important it is to the business. It's not also an also ran. Risk management, I feel, is done really poorly. So I've recently joined a board, and when I asked to see the risk register, they said they didn't have any risks. I said, well, that's a first for me. You have no risks at all in your business. No, no, no. Well, of course, that's absolute nonsense. And so when we started doing the exercise on looking at what are the things that can go wrong, oh my gosh, I'd never thought of that. You know, and what about these black swans that are becoming more like white swans these days, you know, from wars and tsunamis and volcanoes and lockdown? You know, oh, well, we know we didn't think that would happen, but there's still risks, aren't there? Because they could happen. So as non-execs, you need to grasp hold of this. You are by law required to manage risk, with most people having no idea what to do about it. So that's some low-hanging fruit that you can get your hands on quickly. Proper accounting records. I said, you know, that's one of the top reasons why directors and companies are prosecuted. You know, this is just housekeeping. I cannot understand how you can't get this right. But I don't know if you know, ladies and gentlemen, the 2006 Act gave Companies House the right to bring individual prosecutions against directors for failure to file accounts and confirmation statements on time. So it used to be that they were just fined £100. Now, Company House can fine an individual director up to £3,000 per person. And for a public company, it's up to £7,000. Now, I'm not going to say they're going to send you a bill the day you're late, but it's not difficult to sort this out. So, these are things that you can help them put in some sort of order, calendar, for God's sake. 9 months after the year end, you've got to send this in. It's not a big deal, is it? The other thing that the 2006 Act brought in is if the company you're working for is of an auditable size, not only do we now have to write a director's report, but we have to write a strategic report. This is a much, much more commercially sensitive document because it has to talk about the key risks and uncertainties that the business is facing in the next 12 months. It has to talk about the KPIs that you're measuring at board level. That's one of the first things I stop, that if I join a board, they're measuring things at board level that I would not want to be in the public domain. We manage them and measure them at management level, not at board level. But the point of this discussion is that when the law came out about writing this strategic report, if you are fraudulent, clearly you're going to be liable for that. But if you're negligent in that, so you don't say something that is clearly a risk, then you will also be liable for that. So negligence is being classed on the same classification as fraud, which is why you'll find if you look at a few sets of accounts now, that while a director's report might be, a page, strategic report are pages and pages long. I've got an interesting situation at the moment. I've got a client that makes sausages, £75 million of them. 99% go to one supermarket with no contract. Now, that's a very interesting problem to put in a strategic report. Okay. Now, of course, we're not going to say who the supermarket is, and we're not going to say it's 99% plus, but you have to read between the lines. The very vast proportion of these products go to a national supermarket where there is no formal contract in place. However, the products are branded, the relationship's gone on for years, and that's the spin. We're not lying, but we're making it perhaps look more positive than it actually is. So if you're not aware of the 7 duties of directors, I suggest you write these down. This is the Road Traffic Act for directors. If you break these and you're caught, because of course it's all about being caught, then you will be prosecuted. You're not going to prison. It's a civil offence. But to be absolutely honest, being disqualified as a director holds to me the same fear of going to prison because it's game over. So the first is act within your powers, okay? You find your powers in your articles of association. So many directors I met have never read their articles of association, yet that's the rule book. Now, they can be quite vanilla. They can say you can do whatever you like as long as it's legal. So one of the first things I introduce when I join a board as a non-exec is something called powers reserved for the board. And that is totally the opposite of delegated schemes of authority. What it does is it provides a list of all the things that no single director may do unilaterally. That is hugely important for non-exec directors, because if somebody does do something that they're not allowed to do, they've acted what we call in law ultra vires, beyond their powers. And therefore it changes the litigation process. There is a sample of this on my website, so please go and have a look at it. It's the first thing I do. So the next one, and I just hinted at the fact that you must put the company first. That's your job. So we call it in law promoting the success of the company. It isn't just putting the company first and never mind everybody else. It's putting the company first, but considering the other stakeholders. If you look at the law on this, if you type in 7 duties on directors into Google, it will give you these 7 duties. Exercise independent judgment. We talk about management teams. A board is not a team. A board is a group of individuals. Until they make a decision, then they are a team in terms of the implementation of it. One thing I recommend you have in your service contract is the right to take independent advice that will be paid for by the company. On my service contract sample, that is in, otherwise you have to pay for it yourself. So independent judgment. So you have to act independently. So if you find your independence is being challenged for a reason, you need to take advice. And advice is expensive. So you need a clause in your contract to say that advice will be paid for up to X. Now, in a public company, if you take a public company role, under the UK Corporate Governance Act, the company has to pay for it, explain why, but not in private companies. Okay, so next is care, skill, and diligence. Now, you've always had to act carefully, but, how careful is careful? Well, if I tell you the only criteria to be a director in the UK is following. If you're human, because actually you don't have to be human to be a director. As Elon Musk made his dog CEO, okay? But actually when I talk about non-humans, I'm talking about corporates. So you're going to be a corporate director. But if you're human, this is the criteria. 16, not sectioned under the Mental Health Act. Not insolvent currently, so not an in-discharge bankrupt. So sane, 16, solvent, and not serving a sentence for an indictable offence, which, ladies and gentlemen, includes speeding at over 100 miles an hour and includes drink driving over a certain amount. You'd be automatically disqualified. So the bar's quite low, but that doesn't mean you can get away with acting like a sane 16-year-old. Test is, are you acting like somebody with your background and skills have? The next is avoid, which is a very interesting word in law. So it doesn't say you can't. Avoid a conflict of interest. Just to give you a bit of clarity on this, a conflict of interest isn't just you. It is your legal associated persons who are your other half, your children, your stepchildren, your parents, and any of those people who are more than 20% shareholders in the business that you may have a conflict with. The next is not to accept a benefit from a third party. This is not the Bribery Act. The Bribery Act is a criminal act. This is the Companies Act, and it says no director can have anything at all from the company unless the shareholders give permission, which is why you need a service contract, because service contracts are approved by shareholders. Even if that doesn't go through a formal shareholders meeting, the fact that you've got one is sufficient to say it's approval. But you can't have any other benefits, so no cards, no bonuses, unless it is all in that contract. And the final thing is make sure you declare interest in any other commercial activity that you or your connected parties are involved in. So that's not a conflict. That is any other commercial activity. So I've got 2 buy-to-let houses in Leeds, nothing to do with anything I do, but it's a commercial activity and you have to declare it. So just very quickly, Sarah, this is my summary. Get a really great service contract with all the things I've mentioned there. Ensure you've got directors and officers liability insurance with run-off cover. Have a clause that allow you to take advice from external people, and that's paid for. Have the right in your contract to keep board papers and board minutes when you leave, because those are your evidence. And if you're thinking, well, I've got them anyway, they all come in soft copy, they're not yours. They belong to the company. So you need specific permission to have that. And put in place reserve powers for the board. There's quite a lot to take on board, and I hope you've enjoyed it.
Jo, that was phenomenally helpful. So I really, really appreciate you giving the time of sharing those thoughts with us. With greatness comes liability, and I hope that you feel really educated and empowered by hearing Jo's tips. We are now going to have a little moment to pause and to reflect on this for yourself. So we've got 3 questions, and I'll just pull them up on the screen. So the first is, do you feel worried personally about any particular liabilities? Has anything come up in this talk that's got you thinking? Did you realise what the directors and officers liability does and what it doesn't provide for you? And lastly, what changes do you intend to make about how you carry out your role? We're going to have a few minutes now just to think about those questions, and then we'll jump into breakout rooms.